Hey there. Are you wondering WTF is up with Nike suing over these Satan shoes? Don't worry, I've got you. Today, I'm going to do a quick breakdown of what's happening in that case, what Nike's arguing, what the temporary restraining order means, what MSCHF is saying to defend themselves, how Lil Nas X is involved in this anyway. He's not being sued by Nike, by the way, and what I think is going to happen going forward in this case, because MSCHF already shipped the shoes. I'm seeing people getting the shoes on social media. So the shoes have shipped, but there's a temporary restraining order. There's another court hearing coming up at the end of April, and it's a lot of information to cover. And we're going to try to keep it to a case brief so that you know what's happening without sitting through 3 hours of video. So let's get into the case brief. Nike versus MSCHF suing over Satan shoes. Let's get into it. Hey there, welcome to The Emily Show. I'm your host, Emily D. Baker, badass lawyer and everyone's favorite legal commentator, breaking down the legal shit in the news and pop culture stories you want to talk about. I've been a licensed attorney for over 15 years, I'm a former prosecutor, and I'm a big fan of the cursey words. So let's break it down. If it feels like all of this has happened very quickly with Nike and the Satan shoes, you're right. This has all happened very, very quickly. Corporate counsel somewhere is making bank, working their ass off on this case because all of this just sped right along. This started March 26th when Twitter account Saint announced the collab between MSCHF and Lil Nas X over on the Twitter. That's right. The collab was between MSCHF and Lil Nas X, not between Nike and the devil. Some people believe that it is. And that really is the heart of the problem in this case because Nike is arguing essentially that this is damaging their brand reputation because people are confused about the shoes. Well, you're going to have to tell me. You're going to have to tell me if you're confused about the shoes. As I said, this popped off on March 26th when the Twitter account Saint announced this collaboration saying MSCHF X Lil Nas X, quote, Satan shoes. Nike Air Max 97s contains 60 cc's of ink and 1 drop of human blood, 666 pairs individually numbered, $1,018 each, March 29th, 2021. So the announcement was March 26th. The drop was March 29th on the MSCHF app. Now, yes, the tweet does say MSCHF X Lil Nas X, meaning the collab, but it also indicates that the underlying shoe is a Nike Air Max. You know why? Because the underlying shoe is in fact a Nike Air Max. It is not a Nike. It is a Nike shoe. It's a Nike shoe that's been modified with a 666 on the heel with a gold kind of pentagram medallion with the Bible verse Luke 10:18 on the front of the shoe with red ink injected into the kind of air bubble at the bottom of the shoe with a few other detailings. The back of the shoe says MSCHF or Lil Nas X instead of just saying Air Max. The packaging is very satanic-ish, and they have an upside down cross kind of on the top of the tongue of the sneaker. So a modified Nike shoe being sold as an art piece according to MSCHF's filings in court. This also came in collaborations with Lil Nas X's Montero Call Me By Your Name song that recently dropped. So the song dropped, then these shoes dropped. They were doing a giveaway on Good Friday. People feel very attacked by the timing, but the music video, if you haven't seen it, you can go watch it on YouTube, but the music video depicts Lil Nas X going to hell, seducing the devil, killing the devil, becoming the devil. There's a lap dance, there's a stripper pole, there's a very long wig. It's a visual experience. But Lil Nas X has said, and MSCHF has said in their court filings, that the point of this song and the point of the collaboration was to kind of reclaim Lil Nas X. That's not even a thing. Lil Nas X's power as a gay man, as a Black gay man, as somebody who grew up in the church, being told that he was going to hell for his sexual orientation. And this is his way of saying, no, fuck that. I'm gonna be the devil inside, apparently. So that is what it is. In the timing of the thing, when the shoe dropped on March 29th, it sold out in under a minute. And also on March 29th, Nike filed suit in the federal court in New York against MSCHF. On March 30th, 2021, people started getting shipping notices that the Satan shoes were on the way. And you can see those on Twitter and other social medias. And now, as I sit here and record this on April 5th, people are already unboxing those shoes and getting them and sharing them on social media. So these shoes have shipped, which becomes relevant in a minute. On March 30th, Nike filed for a temporary restraining order and preliminary injunction, which we'll go over in a minute. On March 31st, MSCHF responded to the temporary restraining order saying, yo, the shoes all sold. All but one pair has shipped. The one pair that's supposed to be a giveaway, we won't do the giveaway because you've filed this request for temporary restraining order. And we're just done here. Like, we're not going to make them again. So no harm, no foul. Better to ask forgiveness than for permission. On April 1st, Nike responded saying, okay, well, if you've already shipped them, they should be recalled. On April 1st, there was a court hearing and the temporary restraining order was granted, given that Nike had some likelihood of success on the merits of the case. And then they set a motion for April 23rd for a preliminary injunction. A preliminary injunction means that whatever actions are in the temporary restraining order are going to be held through until the case is resolved. What will be interesting to see is if this gets modified now that Nike is aware that MSCHF has shipped all 665 pairs of shoes. Nike is going to argue that those should be recalled. MSCHF is going to argue that that would be ridiculous and they shouldn't be recalled. Can you imagine getting that recall notice? It's like, hi, these highly coveted shoes that sold out in a minute are being recalled. Could you please send them back to us to burn? People would be like, nah, I've already resold them on eBay. There's no way for me to track them back down because now that these are in kind of the stream of commerce, in the flow of commerce, it's going to be very hard to get the shoes back. I mean, would you give the shoes back? Let me know. Let me know if you would give the shoes back because I don't know if I would. And it seems that a lot of people did buy them to resell them. There were quite a lot of posts for these shoes on eBay, even before the shipping notices went out. And people were saying, hey, confirmed purchase. So you can buy them on eBay because I have a confirmed order. And then when I get the shoes, I'll ship them to you. So let's talk about what WTF is Nike suing for. Nike is suing MSCHF Production Studio Inc. for trademark infringement in violation of 15 USC 1114, false designation of origin / unfair competition in violation of 15 USC 1125, trademark dilution in violation of 15 USC 1125. And these USCs are United States Code. This is a federal case in the Eastern District of New York. And then common law trademark infringement and unfair competition. Nike took it directly to where MSCHF is. They're like, look, MSCHF is a New York-based company. We're just going to bring it to you. We're an Oregon-based company. We don't want to fight over jurisdiction. We're just going to come to your backyard and handle this. For those of you that have been following my content for any period of time, you're all going, oh, good. There's no question of jurisdiction because Nike just took it directly to where MSCHF is. Again, easy for a large corporation to do. They can just say, we're not going to choose to deal with that. Let's get to the heart of these charges real quick. The essential overview of this is the shoe is a Nike shoe, but it has been so modified that it will now either dilute the brand. And so the trademark in the swoosh and the name Nike are going to be damaged or diluted because of this connection to the Satan shoe, or that the shoes have been altered so much that now the Nike swoosh is on a shoe that's no longer properly a Nike product. So it's now almost a counterfeit. That's that designation of origin. We don't know as a consumer where that shoe came from. Remember that the heart of trademark is that you understand the origin of the thing, who you bought it from. You understand that if you see that swoosh on a shoe, it's a Nike. You understand that if you see those swirly white letters on a red can, it's a Coca-Cola. You know that these are from who they say they're from. And Nike argues that that can happen both in the downstream effect. So when somebody picks up these shoes after the retail market or the resale market and beyond. And that's the heart of the trademark allegations. Let's jump into a little bit of my thoughts. I think that when it comes to these trademark allegations, the dilution of the mark becomes kind of the stronger argument. I don't know if Nike is going to succeed on the designation of origin, but they might, because the argument for them is going to be, hey, people actually think this is a Nike collaboration. People actually think this is a Nike shoe. I think that goes to the brand dilution, but some might say, no, it's also confusing that these didn't actually ship directly from Nike. These shoes in this form with these modifications are no longer a Nike product, and therefore it's misuse of the brand. I have seen a lot of confusion on social media about these shoes. The marketing images on social media were Lil Nas X with a bright red background holding the shoe. It's a black shoe with that big white Nike swoosh, and there was outrage. The Twitters were a Twitter. I think Nike had no option but to sue over this to protect its trademark because of the outrage, but also because of the confusion. It was not like, oh, how dare MSCHF make this shoe out of a Nike shoe? It was, oh, how dare Nike make this shoe? And there really did seem on social media to be genuine confusion about whether this was a authorized Nike collaboration, whether Nike was producing this shoe, and where this shoe came from. So perhaps the designation does stand a chance. Perhaps the brand dilution does stand a chance. I think on those two, they have some solid arguments here because based on A, the law, and B, the confusion that I've seen, whether it will be considered trademark infringement, the infringement argument really being at this point, hey, you've altered this shoe so much that the Nike swoosh is on it, but that's not our swoosh on our product that we controlled. Therefore, you're using our trademark illegally. That normally wouldn't be a problem where something's modified because the shoe was origin a Nike shoe. So the argument becomes it's been changed so much that it's now almost a counterfeit good on the shoe because the shoe's changed, so it's no longer a Nike shoe. It'll be interesting to see how those two arguments play. Like, it's changed so much, it's now almost like using a counterfeit mark because you're using this Nike mark on this shoe that's no longer a Nike because of the changes. But then also, you haven't changed it enough that it's still confusing in the marketplace and people still think it's a Nike shoe. People only think it's a Nike shoe because it's a black shoe with that bright white Nike swoosh, and all the marketing materials just had Lil Nas X's face with some devilishly yellow contacts holding up the shoe. And if you go to my socials, you'll see pictures of that. So that is the heart of the lawsuit. The lawsuit itself did not ask for an injunction. That was asked for the next day. In the motion for a temporary restraining order, Nike argued that the only way to protect the brand was to stop these shoes from going out, that the shoes are likely to cause such significant damage to the brand if people are just out walking around in them, because the average consumer, the average person on the street will again see that bright white Nike swoosh and will not know that these are not genuine Nike Airs that came from Nike. The argument being that there is so much outrage over this already, that people are already so clearly confused that they need to stop the shoes from getting out into commerce. The arguments that the swoosh is a famous mark, which we know it's one of the most recognizable brand marks in the world. It's the right of Nike as the trademark owner to maintain control over how its products go out, that MSCHF or MSCHF is capitalizing on Nike's good name to sell these shoes along with the outrage of the sneaker, and that the only real option for the brand is to have that temporary restraining order. And the court agreed, but let's talk about what MSCHF's response was to this. So first, MSCHF responded on Twitter. I'm just going to read their statement because Nike made a statement in its lawsuit. So let's hear MSCHF's statement that was again released on the Saint Twitter account on April 1st. The following is an official statement regarding the court case between MSCHF and Nike. MSCHF is a conceptual art collective known for interventions that engage fashion, art, tech, and capitalism in various, often unexpected mediums. We believe it is better to make art that participates directly in its subject matter. It is stronger to do a thing than to talk about a thing. MSCHF makes artworks that live directly in the systems they critique, instead of hiding inside white-walled galleries. There is no better way to start a conversation about consumer culture than by participating in consumer culture. Side note, we're going to get to that in a minute when they sell the lawsuit t-shirt, but we're not there yet. We choose a specific medium to engage with a specific subject matter. We will make shoes, stream video, publish books, make paintings and sculpture, build apps or web services. Everything is in service to the concept. MSCHF is fully context chameleonic. I didn't know that was a word. 1 year ago, we released the Jesus shoe. As a manifested speculative artwork, Jesus shoes conflates celebrity collab culture and brand worship with religious worship into a limited edition line of art objects. Last week's release of the Satan shoe in collaboration with Lil Nas X was no different. Satan shoes started a conversation while also living natively in its space. It is an art created for people to observe, speculate on, purchase, and own. Heresy only exists in relation to doctrine. Who is Nike to censor one but not the other? Satan is as much a part of the art historical canon as Jesus. From Renaissance hellmouths to Milton, Satan exists as the challenger to the ultimate authority. We were delighted to work with Lil Nas X on Satan shoes and continue this dialogue. We are not affiliated with Nike, as we have constantly iterated to the press. We were honestly surprised by the action Nike has taken, and immediately after Nike's counsel sent us notice, we reached out but received no response. MSCHF strongly believes in the freedom of expression, and nothing is more important than our ability and the ability of other artists like us to continue with our work over the coming years. We look forward to working with Nike and the court to resolve this case in the most expeditious manner. Given the current circumstances, this action by Nike will also prohibit Lil Nas X's Twitter giveaway for Satan Shoes Edition 666 from happening indefinitely. We appreciate everyone's patience and continued support during the process. Now, that was released April 1st. The very bottom of the statement says, better to reign in hell than serve in heaven. They've definitely doubled down. With that, the court issued a temporary restraining order. The response from MSCHF to Nike's motion for temporary restraining order reads very much like their press release. They point out that the Satan shoe is not any different than the Jesus shoe, and Nike didn't sue over Jesus, even though there was outrage over that shoe too, because it was blasphemous, according to the tweets attached in the letter from MSCHF Studios to the court. MSCHF Studios talks about the fact that there is no threat of irreparable harm related to the shoes because the shoes have sold and shipped, that they're not going to damage Nike's brand, that the consumers in this case are a very sophisticated consumer. They understand that what they're buying is a MSCHF product and not a product direct from Nike, that it's a customized art piece and not just a shoe. The $1,000 price tag gives it away. The fact that you have to buy it on MSCHF's app and not through Nike.com or any other resale outlet should give it away. Of course, Nike's going to argue that the average consumer seeing the swoosh is going to be confused, which we've seen on Twitter. But people who are highly engaged are not going to be confused. Yes, if this argument sounds familiar, it is the same arguments that went on in the Taylor Swift Evermore case, where Taylor Swift's lawyers were arguing, look, Swifties who are seeking out Evermore, the album, are highly sophisticated. They're going to make sure that what they're getting is a Taylor Swift product. They're not going to confuse it with the theme park. And the theme park was trying to say, yeah, but people might confuse the two. Same thing here. MSCHF is arguing, look, our consumers are very savvy. They know how to purchase our shoes. And Nike's arguing, yes, but somebody on the street might not. And clearly Twitter does not. The Twitter sphere is confused. And I've got to say, I've seen that too. I've seen a lot of outrage and confusion over these shoes. Let's talk about what the court said in this temporary restraining order. The court said that, quote, plaintiff Nike Inc. filed this action against MSCHF Product Studios Inc., alleging violations of several trademark statutes and common law in connection with MSCHF's marketing of a, quote, Satan shoe bearing Nike's trademark. Nike has moved for a temporary restraining order to show cause for a preliminary injunction pursuant to the Lanham Act, and that's the statute that covers the trademark stuff. The preliminary injunction, again, will hold this over until the suit is resolved. The court reviewed plaintiff's complaint, the memorandum of law in support of plaintiff's motion for a TRO and preliminary injunction, the supporting declarations, and other evidence submitted therewith. For the reasons set forth below, I grant plaintiff's motion for a temporary restraining order pending resolution of its motion for a preliminary injunction. And I will cover this more in depth before that hearing for preliminary injunction, because I expect that more documents will be filed by the parties. Based on this limited record, I conclude the facts set forth in the above mentioned materials offer sufficient evidence that, one, Nike is the owner of the Nike wordmark and the Nike swoosh design. On March 29th, MSCHF took orders for 666 pairs of Satan shoes. Well, actually 665 because one of them is a giveaway, but I digress. The Satan shoes contain the swoosh design and were marketed using the Nike word mark. MSCHF also used Nike's trademark and logo on its website in several places. Nike has not given approval for MSCHF's use of Nike's mark. Nike has shown a likelihood of success on at least some of its claims. Specifically, Nike has carried its burden at this stage of showing that MSCHF's actions are likely to confuse and likely are confusing consumers about the origin, sponsorship, or approval of MSCHF's goods. Nike has also demonstrated that MSCHF's actions are likely to dilute and tarnish Nike's marks. I think the court is right on that based on just what I've observed. Nike has also demonstrated a likelihood of irreparable harm absent this temporary restraining order. On the record before me, defendant has not rebutted the presumption of irreparable harm. And I find that issuance of the requested temporary restraining order is in the public interest, and that the harm to Nike in denying this motion outweighs the harm to MSCHF in granting it. Thus, on this limited record, I find that a temporary restraining order is necessary pending resolution of the motion for preliminary injunction. Defendant has asserted a First Amendment defense based on purported expression embodied by defendant's production and sale of the Satan shoes. I'll get to that in a minute. First Amendment rights of artistic expression are paramount, and defendant will have a full opportunity to pursue this affirmative defense at the preliminary injunction stage if it chooses. The burden lies with the defendant, however, that's MSCHF, on the affirmative defense, as counsel for MSCHF acknowledged at oral argument. As of now, based on the limited record before me, defendant has not carried the burden. So the burden being, why is the First Amendment right outweighing Nike's right to protect its shoe on its trademark because it is a business that operates in commerce? The temporary restraining order is granted, it's so ordered, and it prevents MSCHF from doing the following: fulfilling any orders for defendant Satan shoes. Here's the thing. This was ordered April 1st, and it looks like people were getting their shipping statements from March 30th. The timing of when these shoes shipped will be very important, because I'm sure Nike is going to go to the court and be like, if this shit has shipped, you need to recall it, because they said that in their motion. And if it shipped after this was issued, then there need to be additional penalties for disregarding the court's order. I don't know if that has happened. We will see if Nike has proof of that and can argue that. MSCHF is also enjoined from using the Nike wordmark or the Nike swoosh, referring to or using any prohibited marks in advertising, marketing, promotion, or helping anyone else do the same. Now, what I haven't mentioned is part of what poked the bear on this, and I wonder how the court took it. I did not hear the hearing for the preliminary injunction, but in Nike's motion or their response to the court before the oral argument on April 1st, Nike indicated that MSCHF was not taking this seriously, that MSCHF essentially baited Nike into suing, and that MSCHF even put up for sale a shirt, a whole ass shirt called Legal Fees, and they are charging $66.60. And it is a red shirt with little devil horns on it and the face page of the lawsuit, which I think is copyrighted to the attorneys that wrote it. I don't think you can actually do that. MSCHF is like MSCHF managed. We don't give any of the fucks. So we're selling it. It's hilarious to me. It's shady. It also riled the Nike lawyers, which rightfully so. Like if I was a Nike lawyer, I'd be like, are you joking me that this is what you're doing right now? However, if I was working at MSCHF, I would be like, damn the man, save the empire. So I get it. Like I get it from both, because the shade is, magnificent. But also, if you're engaged in this kind of a lawsuit, it would be deeply, deeply frustrating. So MSCHF is going to continue arguing First Amendment artistic expression savvy buyers. Nike's going to continue to argue, yeah, but everyone thinks these are Nike shoes, they're Satan shoes, and we can't have that. It tarnishes our brand. I would love to hear what you think about this case. I am going to break it down more after the preliminary injunction. It will be very interesting to see if that's granted, see what additional things are filed, and see what the court finds. I am going to be following this case to the end because I think it sparks on a lot of topics that are really important to not just creators, but to individuals and to resellers. Like, where are the boundaries between modifying and reselling? And what is the court going to establish going forward with this? Or is MSCHF going to be like, yeah, we got a whole bunch of publicity off of that. We're super grateful. We're cool now. Nike, how can we make it right? Like, how can we make it nice with you? We would like to not be in this lawsuit anymore. We're done. We'll use Adidas for our next shoe. Now, mind you, the MSCHF brand also made a Birkenstock shoe, but it was spelled Birkin like the Birkin bag, not Birkin like the Birkenstock shoe sandal thing. And they cut up Birkin bags. Yeah, like the ones that retail for well over $10,000 and have like a waiting list, those bags, the Birkin bags, they cut up Birkin bags and made Birkenstock sandals out of them. So this is not their first foray. Foyer? Not foyer. Foray. With footwear. I was trying to make an alliteration and failed. I failed on the footwear foray by saying foyer. Either way, that is the TLDR with Nike and the Satan shoes. Lil Nas X isn't being sued. He's not involved with this at all, but I'm sure that all this drama definitely boosted streams and downloads of his song, which is available now if you want to go check it out. I mean, hashtag not sponsored, but it's kind of a bop. I'm just going to be honest. It kind of is. I would love to hear your thoughts on this down below. Do you think people are getting too riled up about this? Do you think that Nike should be defending its trademark? I mean, they kind of have to. That's kind of the basic fundamentals of trademark rights. Do you think the Satan shoes kind of fire? You've gotten to see pictures of it. I would love to hear what you think down below. Join me for the next one. There will be more case briefs on this channel to get you caught up when we are not streaming live. Go ahead and check out all the socials, and I will see you in the next one. Thanks for being here, Law Nerd. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube. I'm going to be following. Here, MSCHF is a conceptual art collective known for in their press release, not press release. See, when I say lawsuits are becoming press releases.